Hello, everyone. I'm Kithan Yau. I am a civil rights and workers' rights lawyer. I also co-chair the Pro Bono and Community Service Committee of the Asian American Bar Association of New York. And as such, I am honored to be a member of the COVID-19 Recovery Task Force. And it is my honor today to be providing you this module on cross-lingual and multilingual lawyering and ensuring access to appropriate language support for our clients. So first, let's go over our goals. There are two goals today. One, we need to have a common vocabulary and framework for how language shapes our communication and how we build relationship with our clients. Second, we are going to be talking about how to effectively work with interpreters to improve that communication in our office, in the field, in the courts. So we're going to be talking about the process, we're going to talk about the interpreter's role, and we're going to be talking about how we as lawyers can make it better. First, interpretation is the term that we use to refer to oral interpretation of one language into another. And it means staying as close to the actual words spoken without adding, deleting, or editing. And good interpretation would also convey tone, register, and emotion. And when working with an interpreter, we have to keep in mind that good interpretation is a highly skilled activity. And it's very different from other language negotiation techniques, like my haggling with a vendor in a country I visit for a souvenir. Paraphrasing and summarizing are also two language negotiation techniques. They are very helpful, but they are not interpretation. Translation is the term that we use for written interpretation. Very often in our day-to-day discussion, we would use, we would ask questions like, do you need a translator? Well, actually, we're really calling for an interpreter. And translation is working between two different languages, two different written languages. And sight translation is working from a written document into a verbal translation or interpretation immediately. So in order to understand why we need to ensure that there is competent and effective language access for our client, we should also understand what's being lost without it. We lose details, we lose emotion, we lose timelines, coherency, fluency, eye contact, motivation. And we know all of these are what makes sure that we can assess a client's credibility and how any fact finder is going to be able to assess a client's credibility. We also know these are the details that make sure we're able to truly understand what happened to our client. So who needs an interpreter then? When a client or pro se party asks for one, when a client prefers to speak or is just more fluent in a language that we're not capable of speaking, and when there are communication challenges, like someone who's hard of hearing, who's wearing a hearing aid, someone who's only able to sight read, someone who's only able to read by touch through Braille, or when someone has a mental or developmental disability that affects her processing. All of those pose communication challenges. We're not going to delve into those particular challenges today, but I wanted to highlight for you that they do pose challenges, and you will need to find an interpreter to help you interpret that communication, even though that interpreter is not the kind that we're talking about today necessarily. Who needs an interpreter? Well, a client who's assessed by you as needing an interpreter. Very often after a brief conversation, you see that the client actually has very limited English proficiency. Her grammar and her syntax is off. She's giving you very lean stories, devoid of details and emotion. We also know that day-to-day conversation is very different from the English that we use in the law or in the courtroom. It's been said that people need to have about 2 years of education post high school in order to fully understand legal language. And we also need to recognize that the effect of stress will have on how capable the interpreter is in continuing interpretation, and the effect of stress it would have on our client in telling us what happened to her. If interpretation is not for amateurs, who should be doing interpretation? In my assessment, paraprofessionals are only appropriate for very simple, straightforward situations, like scheduling an appointment for you with the client. In almost all legal work, a professional interpreter is needed. Interviews, meetings, particularly appearances before tribunals. Family members are rarely, if ever, appropriate, and children must never be used for interpretation. So far, what have we learned about interpretive process? It's communication that's mediated through a third party, essentially, in this case, an interpreter. And in this interpretive process, this communication process, there are much room for misunderstanding and mistakes, right? First, the speaker has to be able to turn her intention into words, into certain utterances that the interpreter needs to understand. And then the interpreter needs to turn that understanding into words of her own, and then turn it into utterances that the listener, in this case, ourselves, as lawyers understand. And in this complicated process, we know that there are going to be difficulties in interpretation. There are going to be challenging cognitive tasks. There are going to be difficulty in understanding dialects, mutually intelligible, right? Where the same word can have different meanings in different culture, and vice versa, where different words could actually mean the same thing dependent on the culture. It's going to be dependent on the cultural context. Different idioms or euphemisms are going to have different meanings dependent on the culture. And we're going to know that language used are going to be dependent on the domain, right? Law is one specific domain. And register is going to be difficult in interpreting. Register, is the client using a word like speak, but the interpreter is actually using the word in English, discuss. That's a difference in formality, and that has an impact on assessing a client's credibility. And what can an office do to help this? Some best practices that I would suggest would be make sure every office has a protocol that addresses exactly this. Avoid calling upon staff who are non-professionals, who may speak the client's language to interpret in even simple conversations. Use the same interpreter for the same client, for the same case matter. Retain competent interpreters or competent, good agencies that would provide you with competent interpreters. Keep a data bank of these interactions. It would not only help you, but would help your colleagues in the same firm. Use 24-hour on-demand interpretive language assistance like Language Line in New York State. If interpretation is not for amateurs, who's qualified? Here's a visual representation. The interpreter must understand the legal concepts. must be fluent in 2 languages, must have cultural familiarity and understand that interpretive process, must have a good memory and be quick, right, to be able to manipulate and use the correct dialects and registers. A good interpreter would also understand her role and understand that she must keep the information confidential. And here is a visual representation of what, as lawyers, we must do in order to prepare an interpreter to provide effective interpretation. We need to review with the interpreter the legal concepts that are going to be involved. What are the goals of the interview? We need to determine whether the interpreter's cultural experience is a good fit for our client. We need to make sure that the interpreter has the adequate skills. We need to make sure that she's doing basic things like taking notes in the first person, because you're going to be speaking in the first person. And whether the 2 of you have had a plan for highlighting mistakes or these difficulties. And you would have explained to the interpreter her role, and make sure that you have written and make sure that the interpreter have signed a confidentiality agreement. What else can we do as an attorney to help this process after we have prepared an interpreter? Well, there are actually quite a bit. And we're going to keep it simple, stupid, but we're not going to keep it stupid. Here are some suggestions. These suggestions are merely suggestions. They are not all inclusive. In addition to these suggestions, I have also provided to you the list of suggestions that we give to our own volunteers for Asian American Bar Association's Pro Bono Clinic. Many of them are actually very similar to these, but there are some additional ones. I encourage you to review both lists. They offer good suggestions. And we need to pay attention. We need to make sure that we are flagging situations that we need to be able to correct if necessary. So here, I would like you to watch this video, and I encourage you to both listen and read the subtitles.
What did he say? Sometimes a fatal error starts with a simple misunderstanding. Watch what happens here. The officer's line of questioning centers on the fact that this applicant's organization has been associated with terrorist acts. The officer wants to make sure that the applicant himself hasn't committed violent acts.
All right. Have you ever hurt anybody in India?
किसी एक आदमी ने इंडिया में सुनिया है किसी आदमी ने सुने
Just tell me what he says.
He says have you heard anybody in India what mean?
Okay. That's what I want you to tell me. I mean, as a member of the AISSF, did you ever hurt anyone to further your political goals?
इस वक्त ऑल इंडिया सिक्स फेडरेशन का कोई आदमी है जो कि इस आगे सपोर्ट करके आगे ले जा रहे हैं कौन है वो
ये वो
हरमिंदर सिंह गिल
You know if he has ever hurt anyone.
उसने सुने कदे
असली क्वेश्चन किया भी उन्होंने किया असली क्वेश्चन
He says, what is the question I want to understand?
I want to know if he has ever done anything to destroy property or to hurt people to further, to advance his political goals.
ਤੁਸੀਂ ਆਪਣੀ ਪਾਰਟੀ ਆਪਣੇ ਇਸ ਮਿਸ਼ਨ ਵਿੱਚ ਕਾਮਯਾਬ ਹੋਣ ਵਾਸਤੇ ਆਲ ਇੰਡੀਆ ਸਿਕਸ ਫੈਡਰੇਸ਼ਨ ਦੇ ਵਿੱਚ ਤੁਸੀਂ ਕਿਸੇ ਨੂੰ ਮਾਰਿਆ ਹੈ ਕਿਸੇ ਨੂੰ ਜ਼ਖਮੀ ਕੀਤਾ ਹੈ ਕਿਸੇ ਨੂੰ ਕੁਝ ਨੁਕਸਾਨ ਪਹੁੰਚਾਇਆ ਹੈ ਪ੍ਰਾਪਰਟੀ ਤੋੜੀ ਹੈ? No, sir.
So I'm going to stop the video here. We have now observed several interpretation mistakes. So let's see if we can identify them. Did we see answers that were non-responsive? Yeah. Were there uninterrupted conversations back and forth between just the interpreter and the client? Yeah. Long conversations interrupted, interpreted with short statements? Yep. And there probably are some questions about the interpreter's fluency in English himself. And that's something to really watch for. And the interpreter actually did not take notes. And that is also a red flag. And what's more is that the client, and in this case, the hearing officers, were not looking at each other, but rather they were looking at the interpreter. And the interpreter provided his own facts in one case. There were hesitation, mumbling, and there were hand gestures, long silences, and the register was inappropriate. We also saw the expression on the client's face. It was clear that he was dumbfounded. And can we imagine, had he not himself said to the interpreter, what is he really asking? And if the interpreter didn't repeat the question, what would have happened, right? Hurts or heard. Mistakes that even two English-speaking people can make. But there are correctives. And in this case, I would like to focus on courtroom conversation. As attorneys, we should be watching the pace. Is someone speaking too fast, too slow? Is the interpreter interpreting in first person? Watch the structure of the questions. Are you speaking in compound questions, asking compound questions, or your opponent? Watch for double negatives and make sure that there are no overlapping conversations. If the court reporter is not going to be able to take down what is being said because there are overlapping conversations, we should not be expecting our interpreter to be able to adequately interpret the conversation. And plan for errors. They are inevitable. So you need to have a plan. And in a courtroom where usually the courts provide their own interpreter, you may want to bring your own interpreter so that you can offer an alternative interpretation as the correct one. And when you identify that there is an other interpretation that is actually more correct, you can object and you can ask to see if the court can ameliorate that situation. You can ask the court reporter for the question and the answer to be read back. You can ask if the court interpreter agrees with your own alternative interpretation. And if not, and if the court is unable to rule, you can ask for permission to ask the witness clarifying questions in order to perhaps not just to make the answers clearer, but to rehabilitate your witness. So here's an example of handling a mistake.
Can you describe your injuries? 請你描寫下你嘅受傷嘅過程。
好，我個頭又痛啦，個頸又痛啦，咁咧膊頭又痛，咁咧擰個頭嗰陣時咧又係好痛嘅，咁同埋咧耷低頭向下面望嗰陣時，好似咁咧，咁又係好痛嘅，咁夜晚仲慘啊，輾轉反側。
My head hurts and I can't sleep at night.
And how have those injuries affected your financial future?
咁今次受傷對你將來嘅財經有咩影響？
唉，嗰個契弟累得我一鑊泡。你知我老闆啊，鐵沙梨嚟噶嘛？佢話我蛇王喎，咁人哋痛啊嘛，點做啫？個傻佬係炒咗我魷啊，叫我翻屋企。
My boss fired me He didn't think I was good anymore.
Now, so here's a very good example. As a native Cantonese Chinese speaker, this really brought home the kind of mistakes that are often made. There were actually two questions. The response that was interpreted for the first question lacked all manner of the body language that the witness was showing. And for the second question, the response actually involved several euphemisms. At one point, he called his boss an iron pear. Well, that means nothing in English. And the interpreter did not provide a literal interpretation, nor did she interpret that actually means a stingy person, a hard ass. He also used the term snick king. What does that mean? She did not provide a literal interpretation, nor did she provide an English equivalent, which would be taking advantage of the situation, that he was being lazy.
Thank you. Can you describe your...
So we're coming to almost the end of this module. Having this module, I hope, brought home to you that adequate language access is tremendously important to providing competent representation to our clients, and that we need to be able to preserve confidences with our clients, even through this third-party mediator that is the interpreter. And we must do this because we have an ethical obligation to provide serious representation. And most of all, we certainly do not want to be accused of exhibiting biased conduct or committing unlawful discrimination based on national origin. Thank you so much for your time and your commitment to access to justice. If you have any questions at all, please feel free to contact Professor Bryant or me. Bye-bye.